Hey, thanks, everybody. If I said we're at an AA meeting, would everybody know what AA is? Archives Anonymous. And I have to say that I'm Jason Barron. I'm a recovering lawyer. It's a 12-step program, and I'm on step 3. So here we go. So, and I'm delighted to be here. Thanks so much for the invite. I want to do a little table setting for public access in the US and talk about the problems. And then it will be obvious that there's a use case for AI, and it's all about backlogs and dark archives. And then I want to talk about agentic AI and some thoughts that some of us have been having about a seamless public access process using elements of AI. And I'll talk a little bit about those and then maybe about black boxes. And I have about 800 slides and 2 hours worth of talk, so I probably will not get through it all, or I'll have to skip at the end and you'll have to just bear with me. So there's 1,500,000 FOI requests filed against 400 components of the executive branch of government in the United States in the last reported figures, and just a tremendous amount of requests from agencies. Agencies are not doing very well. And their problem and the journey I've had as a lawyer since graduating from law school in 1980 is a manual process. We lawyers are manually looking through boxes. FOIA people in the US, and I'm sure in other places, are manually taking in requests, figuring out where to collect information. And then if there's some search methods with keyword searching, the redactions, as we've talked about in this last session here, in sensitivity review, is entirely manual. There is just not an AI process for sensitivity analysis for public access requests. So what can be done about that? And of course, the Emerald City is using AI tools. So I consider us to be in the haunted forest at the moment. This is what the public thinks of when they file FOIA requests, that some people are going to look through these kind of folders. There are folders like this, I'm sure in this building as well as at the National Archives, and there's legacy media with backup tapes. I used to have litigation where backup tapes were the method of restoring email and cartridges, whatever. That's not true anymore. It's a cloud, and the cloud is here. This is where agency records are stored across those 400 agencies, somewhere in the cloud, which really means in Kansas, with lots of servers from Microsoft or Amazon or wherever agencies use, according to federal standards. And 99% of White House records, in particular interest to me, given when I was director of litigation at the National Archives, are right here. They are right here. So let me just make a point about, although I'm going to talk about the entire federal government, but presidents covered under the Presidential Records Act, from Ronald Reagan to Biden, 700 million emails have come into the legal custody of the National Archives, representing about 3 billion pages. That's a very small sliver of the rest of the government, but just with respect to that, the question I have for all of you is, what percentage of those emails are now open to the public, that you can go online and you can look at the National Archives catalog? Let me hear guesses about the percentage. We'll start with 80%, anything less than that. So go ahead. Not zero. Zero. There's a price of right thing in the United States. You have to guess more than the, anyway, so what do people think? 1? 5? 20. Wow, how optimistic. The answer is 0.07. So 500,000, yes, but zero is anyway. So you have to get something. So and it rounds to zero. Basically, the litigation and FOIA requests have opened about 500,000 out of 700 million emails, and the question is why. And so we all kind of know the answer here, and I'll talk about it a little bit. It's not a great mystery. One reason why is that there are only, 10 archivists at each presidential library, and they have so much to do. And if there's 10 million pages in a FOIA queue, they can only open so much. But that isn't really the AI answer to this. Now, I have to say that I was going to, 2 weeks ago, an earthquake happened in the United States. The Presidential Records Act has said that the American people own presidential records from the White House from Ronald Reagan on. There was a tradition from George Washington to Jimmy Carter that they owned their records, but since Nixon, Congress passed a law, we own the records. That's been the law since 1978, applying to Reagan on. When Mar-a-Lago happened, the controversy, Trump taking boxes to his residence, that was presumed to be illegal for several reasons. One, the Presidential Records Act, but also he took classified information. The fact is, though, that 2 weeks ago, the Justice Department came out with an opinion saying that Trump's records are his own, not the American people's. So this is now in litigation, but it is a tremendous blow to open government and really that you can't FOIA presidential records now if the paradigm is that not just Trump, but from Ronald Reagan through Biden and now through the Trump presidencies, they're all the president's own personal records rather than the American people's records. That will take place in litigation. Who knows what will happen? Lawsuits have just been filed on that. However, the bigger point is that the entire government, that the National Archives since June 2024 has now moved to electronic and digital record keeping. There's no more paper coming into the National Archives. It's just electronic or digital created objects post June 24. This legacy paper, but post 2024. So there is a tremendous wave coming from the rest of government, putting aside the White House, and billions of objects. Okay, and Carl Sagan to the right, and I could talk to people about my meeting Carl Sagan when I was 8 years old. Anyway, so so there we are. So it's billions of records. Now let me get to FOIA. Lyndon Johnson reluctantly signed our FOIA in 1966. That was exactly 200 years after Sweden's first FOIA in the world in 1766. He was reluctant, but he said in yellow here that at the same time, welfare of the nation may require that some documents not be made available. Hence, the duty to segregate out information that is exempt. And then the AI issue is, how do you find that? The sensitivity analysis, okay? Responses are slow in the US. This is not atypical for a lawyer to stand up in court and say it will take 17 years. The statute says 20 working days to respond to requests, but lawyers get up with declarants under oath saying 17 years. And my favorite is that the Food and Drug Administration said that it'll take 55 years to answer a FOIA request. This is completely unacceptable. It was a request that caused about 100,000 documents. And I must say that the 100,000 number is not one that should take more than a few weeks to go through, or maybe a week with an AI search method. But then there's a redaction issue, and that's what hangs up federal agencies. So that is the as-is model. I'm not going to read the slide. The first two problems, inadequate resources, we all know, these are problems that are worldwide. There are all sorts of issues with the as-is model. However, technology is important for us in this room, figure out an AI solutions to these gaps and challenges. And I have another slide here, why haven't backlog and resource problems been solved? The first two are, well, particularly these days with this administration, cutting FOIA offices, firing chiefs of FOIA. There's an obvious thing going on about wishing less transparency. That's my own, my own viewpoint. But the key, I think, is technological lag and legal complexity in terms of figuring out how to review documents. It's so labor intensive. And so that's where AI comes in. Okay, now I will pivot to AI. What types of technologies can help improve the process? I want to talk for a moment about the world of tomorrow. And it's not the world today, but it's a world where instead of requesters waiting for some person to talk to them about FOIA requests, they are continuously in dialogue with a chatbot. And the chatbot is not just a rule-based chatbot, but it's a Gen AI empowered chatbot that can have a real dialogue. The chatbot has kind of a Bayesian prior to it. It has knowledge of the 1,000 requests that have already been filed against the agency, or thousands, whatever. So it has a knowledge base of where records are, and it can inform the requester, who may not be, unless they're a very sophisticated public interest group or somebody who's a lawyer, whatever. Most of those 1.5 million requests are not sophisticated enough to give a well-articulated, narrow, precise request that gets them what they want. It's like any and all documents on X, and it's not going to succeed. And so the first level here is a chatbot that can have a dialogue with, and a dialogue throughout the whole process. And then there are various other agents involved in the process, namely ones that do search, ones that do filtering, ones that explain in a narrative what the decision is that an agency has done, and iteratively. And so I will just repeat what I just said in 20 seconds. I'll do for the next 5 minutes. And this slide, I want to thank Devanshu Kurjewal, who's collaborated with me in a workshop that Graham and I are doing in Singapore, along with David Grouse on open government and AI in June. What this represents is a schematic from Notebook that shows the agentic process. One of intake, where agent 1 is my chatbot. Agent 2 is a search using AI methods, machine learning methods that we as lawyers call technology-assisted review or predictive coding, but they're essentially machine learning classifiers of linear regression or support vector machines or whatever classical machine learning there is. Agent 3, review and redaction, here is a potential for sensitivity analysis being applied, and I have to look to Graham as the sort of the gold standard here of your work in the area of using AI for these sensitivities. And I've done a little work as well in that in terms of research. Agent 4 being a Gen AI agent that can write narratives and give an explanation. So it's not a black box, it's a real explanation to requesters as to how the agencies come about to redact or not release documents. And then an agent that basically is kind of an ombudsman auditing the process with the possibility of manual intervention at any of these stages of a human in the loop. But I must say, as I think Robert said earlier up here, a human in the loop slows down the process almost to zero. So I want people to be involved in QC, in sampling and auditing, but if we're insisting that a person, a supervisory person, a real person is looking at every last decision in terms of of what an AI agent has done for sensitivity analysis, we are defaulting to the as-is model. And so we need to really think that through. Now I have 2 or 3 slides here that I don't think are well, can you read this? I don't know whether it's an eye test here or not. I need to do a better job on presenting these schematics, but and I will do this in this fashion. One is there's a loop where essentially the chatbot in the loop is talking to people about their query formulation to make sure that ambiguous terms are clarified, that parameters are narrowed in terms of dates and custodians and portions of collections. So that iterative loop is the first one. There's a second iterative loop where one goes out and searches based on that initial interaction with the chatbot. An agent goes and searches whatever the repositories of an agency are, and then comes back and it will come back after one more loop, which is a sensitivity loop for finding exempt material, and then an explanation. And what this is meant to be, and I will describe it in written form in just a moment, but it's basically what it is giving a sample to people. If there's 1 million documents that are potentially responsive, give 100 that have been reviewed by the AI with perhaps some human review, but an AI looking at it and giving the requester an early look, not waiting 17 years, but for an interim release and whatever it is, and having a dialogue to basically train what the FOIA process would then be. The requester is saying, yes, I want these and not these, go back or I want different individuals involved, whatever. So that's the iterative loop involving that. Now I'm going to walk through the workflow, and I'm going to be mindful of time here. So the request, I'm repeating myself, but I just want to make sure everybody understands what it is that's being proposed in terms of the steps here. So requester asks for all records, let's say a surprise foreign intervention by the US in country X, maybe in the Middle East, with a variety of subparts necessitating multiple searches. So the chatbot is determining which component of an agency is likely to have responsive records. Actually, in the United States, there's a FOIA.gov portal that one could actually go to and then farms out to different agencies, but that's another layer here. But if you're just focusing on one agency, and you have complex requests, need to be clarified. The chatbot does so iteratively based on a priori knowledge, a consensus with the requester, an estimated timeline for a response. The next agent would search databases using whatever machine learning. I emphasize those because in my research, machine learning is still better than LLMs for basic search methods, but we can talk about that. And the chatbot informs the requester of the search and narrowing or clarifying the search parameters. There's a training going on, which is that requester and the chatbot is basically training the agency to do a better job iteratively of figuring out what is part of the request based on samples back. And that hopefully one could have a coherent discussion with most FOIA requests about that. If they want any and all and everything, then the process is going to kick out and stop, and there'd probably be a human intervention on it. But then a Gen AI tool for a final determination letter. I'll try to get to that in a few minutes about what my research has shown about the quality of the determination letters, the explanation to people as to what the agency has come up with. And so a determination letter in a machine readable format, there's a further discussion. And in the US, there can be an administrative appeal to the agency and then judicial review to a federal district court. So can have a discussion with the agent about that. Now, I'm glad that it's only 3:20, so I can go on. I thought that the hourglass would stop me here. Does anybody have any question at the moment before I go on? I don't like to wait till the very end. Not you, James? Okay. So yes, go ahead.
Does it update in real time as to having reformulated the request? Does it give like an estimate? Okay, this will then reduce the time for response.
Well, my dream is that the time for response is going to be much, much narrower if you have this process where the AI is involved and not people, except for some check. So yes, that would be part of it, that we can do this in 3 months and not 55 years. Okay, so back to Carl Sagan, there are two challenges. One is performing searches by themselves of large data repositories. We in the e-discovery community have known what to do for the last 15 years. And based on before the last 15 years in the dark ages of the 20th century, I used to look through boxes of records for responsive documents. Be 100 lawyers in a warehouse looking through boxes. That is not what lawyers do now, and or only at the margins. Morera and Gordon taking the results of something called the Trek legal track that I had something to do with. Around 2011, there's a sea change in the law in the US, and basically lawyers know how to do technology assisted review using machine learning, using classifiers to search for documents. And there's no reason at all why a resourced federal agency or even at the state level can't do the same thing in terms of searching for documents, not using keywords, but using machine learning. So that part of this Agent 2 is a solved problem. The problem that is not solved is segregating out sensitive or privileged material. And in the UK, you have a set of exemptions. We have 9, but there are a few of them that are really important about personal information and about deliberative process, attorney-client, attorney-work product, and law enforcement information. And there's a national security exception for classified documents. That's to the side. But there's there's a small subset of sensitivities that need to be searched for, and it's not, I'm not saying that it's solved. The dark archives problem, and the reason why it's only 0.07% in the US, well, first of all, there's a presumption that everything is closed for 75 years in the US. There are different presumptions in other countries. I don't know whether the UK follows the EU here, but there is a presumption that personal information just on that category is closed until the death of people or it can be determined. And so that's the baseline. The question is, can you overcome that? And you can do it a little bit with manual search, but that's not going to cut it when you have 700 million emails and all sorts of documents. The real problem, other than resource, is this sensitivity process. That's why it's 700s. It's the PII content and the other personal content and the other sensitivities in documents. And so it has been mentioned here today that there are easy categories. Cal said that. Easy categories and difficult categories of PII. And the easy ones is a known issue and can be solved through expressions, or there's vendors out there that advertise their wares and they can redact documents, or on the left-hand column. The right-hand column that includes notions of the GDPR has and cross countries, wherever, is there are problems in terms of finding that. So there's a spectrum here of difficulty. And in terms of using technology-assisted review, what I've concentrated on, I'm just going to give just for a couple of minutes here. My research has not been on personal information. It's been on something called the deliberative process privilege, which is pre-decisional documents that are about the opinions or option statements that are in government. What are we going to do? What are the options for what's going on in the Strait of Hormuz now? Or any other issue that you can think of that is of interest as a public process. What the law is in the US, and it is the law in other places as well, as I believe in the UK and other places, which is that there's a duty to segregate out information in the US that is factual from that which is opinion or option papers or whatever. So you take one document, and I'll go past this slide. You basically have a duty to segregate documents. You can withhold a full document if it's all a deliberative process document or if it's all covered under exception, but there's a duty to segregate. And so the research that I've been involved with is basically finding on either a paragraph level or a sentence level, a more granular level, the portions of documents that are deliberative, that are the option paper, as opposed to the factual. So it's a 0-1, and you're basically asking the AI to redact, basically define the portions of documents that should be redacted. Okay, and the research that we did involved Clinton administration documents involving two individuals, one of whom became a Supreme Court Justice, Elena Kagan. I will not go through this for the interest of time, but my papers are available. And basically training the system to look for opinions versus factual information, using two lawyers to do this, to reach a consensus. I will not read these tables, but the testing and the validation, what it comes to when you look at recall, precision, and something called F1 for this is something on the order of 83% recall that the system has that can find deliberative process privilege material, which is better than a baseline. It is not perfect, and we can have a discussion of whether 70% to 80%, depending on the method, is good enough. Is it good enough to pull out 70% to 80% of the time material that is a candidate for redaction? I'd argue that that is progress. It's not progress if you end up having to look at every document. The other piece of research that I'd want to say, which relates to Agent 4 about explaining or writing letters to essentially having an explanation to requesters as to what the agency did. I can't go through all the slides here, but the question is how well does ChatGPT do that in terms of explaining decisions? And so this is a busy slide, but on the right is a ChatGPT response to a requester about whether a passage in a document would be would be redacted or was redacted. So the discussion here, and I'll just say the discussion here for the ChatGPT with a citation to a case is better than the boilerplate that exists now for FOIA staff and agencies writing back to requesters after 6 months or a year or 5 years or 17 years, getting this kind of boilerplate about the exemption covers this, but not tied to the issues that the requester really wants to know about in terms of this collection of documents, a lack of specifics. So even when this was done on ChatGPT 3.5, we're seeing a better average determination letter than what I see from federal agencies. And of course, ChatGPT has gotten better. We can discuss whether Gen AI LLMs are going to get really, really better or whether there's an asymptotic function in place. Does it do a good job? I'm going to go past this. There's, in terms of citation and case law, it does a pretty good job, not a great job. No hallucinations to speak of in terms of case law, but there was one in terms of a document. The question here is, with respect to sensitive personal information, what can we do? Waiting for every individual named in records to pass away is not an option. We should be advocating for an agentic process that has machine learning for segregation of sensitive products. We, of course, have issues about training or trusting the algorithm. No algorithm is going to do a perfect job, but the right question to ask is how well do humans do? And the delta between humans and AI, what kind of trust level in search and filtering we have, how much risk is an archives willing to take that material would be given out, and how much they tolerate for that, for both false positives and us lawyers, false negatives, not getting the documents we want. So boxes at Mar-a-Lago, well, that's a legal issue that can be dealt with. AI methods and black boxes, the question is how transparent the as-is model of human review is now. I would say that if you're waiting 55 years for a response, it's not so transparent. And I think there's a trade-off between the efficiency, days, weeks, or months, versus a loss in explainability that every institution is going to have to confront. I think AI is a gift, not something to be feared. In terms of access, lawyers are under a duty to be technologically competent. I'm under a professional duty to know when I stand up in court what I'm talking about. And if I don't know AI in particular, I know somebody who I can put on the stand who knows what the process was that I employed to do document review. We have to be that. The question for archivists is not to be held to a professional standard of competence. I'll leave that as an open question, but at least to let go of reluctance. This is a very biased sample in this room in terms of wishing to adopt AI. Question is for the archival profession as a whole. And I'll just leave with this, with apologies to William Gibson. Thanks very much.